Good morning. May it please the Court. My name is Brian Brown, and together with Saul Kruppelman, we're here today representing the appellant petitioner, Hector Butler. Before I begin, Your Honor, Judge Barbera, I want to say what an honor it is to be among the first attorneys to argue before you in your status as chief, and I look forward to your status as a long time in moving our judiciary forward, and I am looking forward to working with you both in and outside of the bar and accomplishing your goals. Also, Your Honor, just preliminarily, when we checked in today, the clerk asked us how much time you want for original and how much you want for rebuttal and who's doing what. We indicated to the clerk that depending on how argument goes, it will either be myself or Mr. Kruppelman who will be doing rebuttal. And the clerk said, well, they like black and white, not gray. So with the Court's permission, depending on what we decide, is it appropriate for which one of us to go ahead and argue?
That would be fine, but I see you have reserved 7 minutes for rebuttal.
That's correct, Your Honor.
Okay.
Thank you very much.
Very good. Mm-hmm.
Your Honor, this case involves lots of issues, and we have a very abbreviated or short period of time, only 30 minutes. So I'm going to do my best, subject to the Court's questioning, to take them one at a time, and hopefully we'll get through it all in the time that we have allotted. The first issue that I'd like to bring to the Court's attention is what I'll call the scheduling order issue. Your Honors, in lead paint cases in Baltimore City, there is a standard scheduling order. It is slightly different, or greatly different, really, than the scheduling orders that are issued in almost every other civil case, in that there is one particular provision that is a provision to allow for the testing of still defendant-owned properties. And that provision reads as follows: defendants who still own a subject property shall allow the plaintiffs to perform a non-destructive test, lead test, upon the premises within 60 days of a written request, provided that the request is made no later than 4 months prior to the discovery deadline in paragraph 2A. The defendants shall be permitted to attend the lead test accompanied by consultants or experts. So it's 2 sentences. The first sentence refers to defendants who still own the property, and the second sentence refers to defendants who those defendants may attend the lead test. They're read together. For years and years, the provision was read, and nobody seemed to quibble with the fact that if the defendant didn't still own the property, this scheduling order provision simply did not apply. Why? Because the first sentence reads, defendants who still own the property.
So you're telling us that the long-standing practice was that if there were other defendants in the case who were prior owners of the property, they were not entitled to come to the test.
That's correct. Just as there's no provision in the scheduling order, Your Honor, for defendants to tell us everything that they may be doing to test properties that may be involved in the case, so too, if the defendant still did not own the property, we don't need to go and tell them what our work product is and what our investigation process is. The entire reason for this scheduling order provision was so that to avoid problems when defendants still owned the property, there was a mechanism contained in the scheduling order to allow that to occur. And that's what that provision was placed there for. But what happened in this case was the defendants moved to exclude the testing by ARC Environmental, and ARC is a testing company that tests for the presence of lead-based paint, because the plaintiffs, petitioners before you today, didn't give them notice that the test was going to occur. But, Your Honors, under the plain, clear language of the scheduling order, this provision only applies to, quote, defendants who still own the property.
Could the test results obtained through this provision be relevant to the liability of other defendants who previously owned the property?
Yes, Your Honor. The purpose of the test is to, let's go back. Sometimes when the defendants are sued for a property that is involved in a case, they no longer own the property when the suit happens. So the answer to your question is yes, these results could be relevant to current defendants.
Could this provision be used to preclude them from attending the test, these non-owning other prior owner defendants?
Well, Your Honor, I don't think we would get that far because under the plain language, the plaintiffs would have no duty to inform them that the test was happening in the first place.
Well, you're notifying the defendants who are the current owners. What if they tell the other defendants?
No, Your Honor, with respect, we're missing the word still. We don't have to notify we have to notify the defendants who still own the property.
And they tell the other defendants who say, I want to be there. You can preclude them from attending by virtue of this language?
I believe that this language, Your Honor, does not give them the right to attend that test because the plain language says only defendants who still own the properties shall be permitted to attend the lead test. So I believe the answer to your question is yes. If we found out ahead of time that some defendant who no longer still owns the property wants to be there, we would have the option, if we so desired, to file a motion for protective order with the court and have the discovery judge make that ruling.
If it were granted, wouldn't that be absurd? Because you said it potentially bears relevance on the potential liability of the non-owning other defendants.
Your Honor,
you could bar them from being there to observe the test.
The reason why it's not absurd is because they could go out and test a non-defendant-owned property, and they have no reciprocal obligation to tell us. So they don't have to tell us that they're going out to test a property, and that could be used to either dispute our liability claim or help us, but we would never know that it occurred because under this provision, if it's read as the respondents here would like the court to read it, they would have no obligation, no reciprocal obligation when they go out and test properties or do community surveys, as they often do, and tell us. So why should this provision, Your Honor, be read that the plaintiff, when they're conducting their investigation, tell the defendants every step of the way what our theory of the case is, how we're going to prove their liability, when they don't have the same reciprocal obligation? Remember that in Dorsey, this court said that discovery is not the only means by which a plaintiff or a defendant may conduct their investigation into the case.
Counsel, what, in your view, is the purpose of this provision in the scheduling order?
I can tell you exactly, Your Honor. The purpose of the scheduling order was, I'll use the word.
This provision that we're discussing right now.
This provision of this scheduling order was designed because, by way of legislative history, for lack of a better way to put it, plaintiffs prior to this provision had an extremely difficult time getting still owning defendants to allow us to test the property so we could find the presence of lead. So, Your Honor, there was a meeting held among the judge in charge of civil, the administrative judge, and members of both sides of the lead paint bar who got together and came up with this provision, among others. But the purpose of this provision was so that still owning defendants would have to, under the terms of the scheduling order, upon the notice set forth in the scheduling order, allow the plaintiffs to come and test the property. That's the purpose of the scheduling order, Your Honor.
Where is this legislative history? I borrowed, it's a good phrase. Where is the legislative history of that provision of the scheduling order?
The legislative history, of course, legislative history isn't included in legislation. The wording of the legislation is the legislation. The legislative history is how the legislation got there. So the history that I spoke of, Your Honor, is not, of course, contained in the scheduling order itself. I was trying to respond to Judge Barbera's question.
I understand. I'm just saying, where would anyone else find this history of how that came to be and why it was there?
I can tell you, Your Honor, that in the amicus brief, there is an affidavit signed by Mr. Nevin, who is another plaintiff's attorney in lead paint cases, who describes this legislative history. And Mr. Kropelman is sitting here to my right, can, if the court so desires, tell the court about the legislative history. But Again,
So it's personal recollections of people who participated in
Yeah, I mean, there-
evolving the language of the standard schedule.
that's fair, Your Honor. There wasn't a court reporter present when the bench called the members of the lead paint bar together, and so it's not recorded, it's not transcribed. So I would say that's a fair statement. It is not it is based on the recollection, but it's also based on, you can see from scheduling orders that were issued prior to the time the meetings occurred, and scheduling orders that happened or were issued by the Circuit Court for Baltimore City after the meetings occurred.
Well, on that point, what are you asking us to do? Are you asking us to take somehow judicial notice of what was the practice before the scheduling order was created?
Your Honor, I don't think we need to get there, because I think all we need to do is look at the plain language of the scheduling order. And the first words of the scheduling order say, defendants who still own the property. And it's undisputed that the respondents who are before you today did not still own the property at the time that the testing occurred in this case. And since the defendants who still own the property are not here, they did not own it at the time the property was tested, they had no right under the plain language of the scheduling order to attend the lead test, which refers back to defendants who still own the property. Yes, Your Honor.
Counsel, if we agree with you about the interpretation of the scheduling order, then isn't the next question, well, okay, the scheduling order should have allowed, well, scheduling order should have caused the ARC report to be excluded.
I'm sorry, Your Honor?
No, I
Did
have it
not.
back. I said it backwards.
Yeah.
I'm sorry. The ARC report should have come in.
Right.
What have you proven with the ARC report, and is it sufficient?
That's a two-part question, Your Honor. So first, we have proven the existence of lead-based paint at the subject property.
Where?
These were exterior tests, Your Honor.
Okay.
So Dr. Klein would then say, based upon the existence of lead-based paint on the exterior of the property.
All right, let me stop for a minute. Did the mother testify that the child never played outside of the house?
No, she did. Did she testify that she did not play outside? Yes.
Okay.
But
So we have lead paint outside, but the child did not play there. What do you conclude from those two facts?
But, Your Honor, as I was saying before you asked your question, together with lead, we have lead on the outside by virtue of the exterior test. Plus, we have, as Dr. Klein said in his affidavit, the age of...
Plus a what?
Dr. Klein said, based in his affidavit, the age of the subject property, the condition of the paint of the subject property, my client's lead level while he was living in the subject property.
But Dr. Klein never visited the property.
Dr. Klein based his opinions, as all experts do, because most experts are not firsthand, are not eyewitnesses
on the ARC
based on the
report?
records. Pardon me?
On the ARC report?
In part, Your Honor. The ARC report was only one small element of what Dr. Klein based his opinion on. But we're sort of getting ahead of ourselves because the trial judge in this case, when she didn't even get to whether Dr. Klein's opinion taken as a whole, even without the ARC report, would have been sufficient for him to conclude there was lead-based paint in the property, which caused my client an injury, which is a substantial contributing factor to his neurocognitive status. She never got there. So that issue about whether the ARC report taking together with everything else isn't really the question with respect that we're here to answer today.
Well, I see it a little differently. It seems to me that, yes, we discussed the interpretation of the scheduling order. Once we finish with that, we move on to these other issues, one of which is Dr. Klein's testimony and the other of which is the ARC report, and those two are somewhat interrelated. Are you saying that the question of whether or not sufficient evidence was proven to get past a motion for summary judgment is not before this Court?
Well, again, Your Honor, that's a two-part question. If you look at the...
With one bottom line.
The answer is, if Dr. Klein's affidavit and his opinions were properly excluded, which we assert they were not, and I'll get to that in a moment, then there was not sufficient evidence. But because Judge White, the trial judge, and this is, I'll transition into the next issue, overreached, in our opinion, with regard to the application of Rodriguez, and in raising motions that were not before the court, she excluded Dr. Klein's report based on a violation of the discovery rules.
Let's assume his report gets in. Let's say we agree with you, she made an error. Report is in. Now let's discuss whether you have proven enough to get by a motion for summary judgment.
Thank you, Your Honor. So, first, Your Honor, just to be clear, we're talking about an affidavit, not a report. I just want to make the record clear. Judge White excluded Dr. Klein's affidavit, but let's just call it his opinions as opposed to affidavit versus report.
Okay.
Absolutely, Your Honor. If Dr. Klein's opinions are admissible, then absolutely
All right,
there has been sufficient evidence.
Let's examine what his opinion is based on.
And now we're talking about two different properties here, so
Right.
just
One is well, you tell me. You know the case better than I do. What exactly is Dr. Klein's opinion based on?
Your Honor, Dr. Klein's opinion is based on a number of factors, and I'll list them for you. His opinion is based on my client's blood lead levels during the time that he lived in the subject properties. It's based on testimonial evidence concerning the condition of the properties.
How long did he live in the subject property? Now, I know they're different with respect to each one.
Your Honor, I don't have that answer at the tip of my tongue because, again...
You should.
Again, Your Honor, I don't think that was an issue that was addressed in the briefs. What the issue was that was addressed in the briefs was whether the trial court erred in excluding Dr. Klein's report. And she excluded Dr. Klein's report not because of substance. The trial judge never reached the issue of whether Dr. Klein had a sufficient factual basis.
I'm trying to get past that point. I'm trying to say, assume that we agree that Judge White erred when she excluded that report. And I'm trying to move to the next step. And you want to dwell on whether or not she erred because you have a better case on those points. I'd like to move to what is your defense to the motion for summary judgment, which did state as a ground that there was insufficient evidence to prove that there was lead paint in this house to which the child was exposed.
Your Honor, our defense was this. Prior to the time that the defendants, respondents here, filed their replies to our response for motion for summary judgment, they introduced no admissible evidence in support of their argument that we could not prove that my client was poisoned there. In response to the motion, Dr. Klein set forth an affidavit that looked at the time my client was residing there, the condition of the property, the age of the property.
But the condition being what? What do you mean by condition?
Chipping, peeling, flaking, deteriorated paint.
Where?
Throughout the property, specifically within the windowsills. It's true, Your Honor, that the ARC report was only on the exterior, but both of these properties were constructed prior to 1950. Both of these properties, Your Honor, contained chipping, peeling, and flaking paint.
When?
During the time that my client resided at the properties.
Did she notify the landlord?
No, Your Honor, she did not, but that's not a requisite element of the plaintiff's prima facie case. She asked me, how can we get past summary judgment in a lead paint case in Baltimore City based upon a violation of the Baltimore City Housing Code, Your Honor. A plaintiff need not prove that the landlord knew or should have known that there was chipping and peeling and flaking paint there, nor need a plaintiff prove that he or she gave notice to the landlord of the defective condition.
So was it the allegations? I'm sorry. It was Ms. Crosby's assertions of what she had, mother's assertions.
Yes, that's correct, Your Honor.
Okay.
She testified in her deposition, and Judge White specifically asked me to provide her with page references from her deposition, which I did during the motions hearing. So the next issue is, excuse me, the next issue is when the trial court raised the issue of our expert disclosure, when conceitedly, both at the hearing at the trial court level and in the briefs before this honorable court, no one had ever challenged the timeliness, sufficiency, completeness of our designation of Dr. Klein as an expert in this case. As a matter of fact, Dr. Klein's deposition had been scheduled by mutual agreement of the parties. And the reason was, and I set this forth in our brief, we had 6 law firms involved in this case at the time, plus we had Dr. Klein. There was never an allegation that we were being dilatory, that we didn't cooperate. But when you have a lot of lawyers who are all very busy, scheduling isn't easy. No dispute that Dr. Klein's deposition was scheduled. Only upon Judge White's assertion that she was going to question me concerning when our expert designation was made, what it contained, did this issue arise. And the problem with this approach, Your Honor, and the problem with the extension of Rodriguez is that, in essence, what the trial court did is treat the scheduling order as a order compelling discovery. And the discovery rules, Dorsey and other cases have held, are completely separate from the scheduling order rule. Discovery is not expanded by the existence of a scheduling order. And what occurred here, Your Honors, is instead of having the lawyers work together if there's a dispute, which the discovery guidelines say, instead of requiring a motion to compel discovery to come first, which is always required, except in cases where there's a complete failure to answer interrogatories or a complete failure to appear for a deposition, a motion to compel must be filed first.
I don't understand this notion of extension of Rodriguez, having written the opinion.
I'm aware of that.
I don't understand this notion. Was that the basis for the judge's ruling? Did she say extension of Rodriguez?
Well, she didn't I'm sorry, Your Honor.
Because in Rodriguez, it was a complete failure of discovery. And so how does this extension of Rodriguez get involved in this case?
Thank you very much for asking that question.
Okay.
So, of course, she did not use the words extension of Rodriguez.
Right.
But in her opinion, she cited Rodriguez. And Your Honor is correct. That's the distinguishing point. In Rodriguez, there was a complete failure of discovery.
Well, I
and in
expect
this
that-
case,
right.
there was not, and the aggrieved parties complained about it.
Well-
In this case, there was no such complete failure of discovery. There was no complaints about the discovery. There was no motion to compel. And so she didn't use the words extension of Rodriguez, but that's the effect. She looked at the scheduling order and Rodriguez and extended it, in essence, to make it a order compelling discovery on its own motion. And as a plaintiff's attorney, or when I come to court, of course, I want to be prepared for what I'm going to face. What is the trial judge going to ask me about? What are the motions? In this case, Your Honors.
Lights.
Thank you, Your Honor. If I may have 1 minute of my rebuttal to conclude.
You certainly may.
Thank you. In this case, because the trial judge raised her own motion sua sponte, didn't tell us what the motions were, didn't tell us what the possible penalties were, we were denied due process, we were denied access to the courts, we were denied opportunity to respond. None of that occurred. Your Honor, I'm going to reserve the rest of my time for rebuttal, but for the record, we would incorporate our arguments submitted in our brief with regard to the Consumer Protection Act and with the trial judge judging credibility by finding she was unimpressed with our evidence on a motion for summary judgment, which is a violation of the summary judgment standard.
All right. Thank you, Mr. Brown. Mr. Daly?
May it please the Court. Your Honor, Chief Judge Barbera, I would echo counsel's comments and compliments. Thank you. Your Honors, I represent two of the defendants in this case, Stanley and Rhoda Rochkind, and they were sued in the case with respect to one of the two properties at issue, 2308 Bryant Avenue. I'm going to speak, just for the Court's reference this morning, on both the ARC testing issue as well as the Consumer Protection Act issue. Mr. Parler, to my left, will be speaking to the Dr. Klein issue, but of course I welcome any questions from Your Honors. On the ARC report, I'm going to speak first specifically to the case and then speak generally to sort of lead paint litigation issues and also sort of weigh in on some of the questions of Your Honors. First, specific to the issue with the ARC report, putting aside expert designation issues, putting aside what was provided, in designations, putting aside notice issues under how testing is done. If we look just case specifically, this is what we were dealing with. The testing was done on August 24th of 2009. The discovery deadline, after having been modified a couple times, was September 9th, 2009. Giving the plaintiffs the benefit of the doubt, assuming we got the report the same day, which we didn't, but giving them the benefit of the doubt, that's 16 days before the conclusion of discovery, we get the ARC report. And again, putting aside the plaintiff side of it, the defendants, just looking from the defendant's perspective, the defendant's obligation as of the scheduling order was, as of August 10th, 2009, 14 days earlier, we were to have laid out our case in terms of our defense testimony, expert testimony. So we get 14 days after that deadline, 14 days after the deadline when we're supposed to lay it out for the court and for the other side as to what our experts are going to do in the case, we get a critical piece of evidence in a lead paint case. And just looking at that, Your Honors, putting aside all the, who should notify, who shouldn't be notified, just looking at that, we respectfully suggest that Judge White's comments on page 2911 of the record ring very true, where she said with respect to the ARC issue, she said, it is too late to do anybody any good, reflecting no good faith compliance with the scheduling order. She talks about notice, and she concludes by saying, and doesn't afford their experts any realistic opportunity to address and respond to the ARC reports.
So what's the point of that, though? I mean, it's 16 days before and all of that. What is it that you're saying as a result? That it was not timely and so it violated the scheduling order? I mean, because maybe I was involved in different civil litigation, but in my experience, it's always up to the wire. And maybe it's just because I represented the United States and people like to take that up to the wire.
No, that's not why it was.
But I mean, it's like things happen on the day that the scheduling order expires.
Your Honor, I've been doing this long. I'll be the last one to disagree with that.
Right.
Everything, lawyers being lawyers, things are done at the last minute.
Right.
No question about that.
Right.
I'm simply pointing out at that point, it was so late in the case, such a critical piece of, the plaintiffs began their brief, as I recall, with a short statement. This is a lead paint case. That's the significance of this evidence. This is an ARC report about the presence of lead in a property. I would respectfully suggest, Your Honor, is the most fundamental piece of evidence in a lead paint case on the liability side of the equation, is whether there is lead in somebody's house. They gave us that evidence 16 days before the deadline of discovery. And after we were supposed to have all of our expert information in. So yeah, it was just, Your Honor's absolutely right. I respect the two gentlemen to my right immensely. We have worked together for years. They're superb lawyers. We work together, and the bar works together. But sometimes, as it gets closer and closer to the sort of real significant deadlines, like motion for summary judgment deadlines, and as we're crawling closer to trial, there just becomes a point where we have to say it's too late. And the plaintiffs certainly can do the same thing as well. I mean, if we introduce an expert report.
So on that, all right, on that point, you read the judge's comments. Did the judge base a ruling to exclude the report, or tie it, if you will, please, to something the judge did or did not rule?
Yes, Your Honor. The judge did rule that the ARC report should not come in, and
For that reason? Or
I
because
think
it was a
for both reasons. I think because in the comment I read, Your Honor, it was both because it was late and because the notice required under the scheduling order was not followed. As I read Judge White's opinions, and again, right around 2911 in the record, Judge White seems to be saying it's both issues. It's a combination. It's just two. And she says later on, she says, you know, all this information came in that absolutely decisively changed the legal landscape of this case. She's talking about it just came in so late, but she did also talk about notification requirements, which I'll address in a moment. So I think it was a combination of the two.
Do I overstate your position by suggesting that I'm hearing from you that she had two independent but equally dispositive grounds for excluding the report?
The ARC report.
The ARC report.
I believe that to be the case, John. I believe that to be the case. She clearly, by her, I don't mean to say she, Judge White, clearly, I think, by her description, by her ruling within the record, seems to be talking about both, seems to be concerned with both issues.
Okay, so then independently excluding the ARC report as a sanction for discovery violation, as well as a violation of the scheduling order, or sorry if I'm confusing the issue here, but I want to be sure I understand.
Well, I don't know that she's specifically saying I don't think she characterized it specifically as a discovery obligation. At this point, you know, it was a hearing on dispositive summary judgment motions, and the question is, you know, the question had come up as to why information came in when it did. And the defense had filed motions for summary judgment on the basis that there was inadequate proof in the plaintiff's case. And the judge then looked at what proof was there. And the issue had been raised. One of the other defendants had moved to strike the ARC report, and because of the timeliness and notice issues. So I think it was a combination, Your Honor.
Well, can we agree that it might be a bit revolutionary in the legal profession if we were to hold that disclosure of information within the discovery deadline was still excludable because it came in late during the discovery? I mean, I'm not trying to make fun of you,
right.
but it's just, it would be really revolutionary.
Yeah,
I mean, because to base it on just, if you're excluding the scheduling order, and just to base it on this, that would be a difficult holding. I mean, it seems to me you have to, go on.
I understand it's still
Right.
within. I was trying to point out to the court, just from a timing standpoint, what the parties and certainly what Judge White was grappling with.
So you have to put it in.
I think you have to consider it all together.
Okay.
But
let's go back.
Without question, notice was certainly a foundation of her opinion.
Right.
Let's go back, please, to the scheduling order itself and the provision at issue here.
Yes, sir.
How do you interpret that provision?
Well, there's a couple points to that, Your Honor. And first, if I may, as a lead into that question, just illustrate to the court, because it really wasn't in the briefing, why notice is so significant. And then we can talk about what the scheduling order says and where it takes us. Notice is so significant, as I indicated to the court. This is a critical piece. This is a critical component of the lead paint case. We have seen over the years, having been involved in the lead paint litigation for longer than I like to admit, over 20 years, and having been around, and I'm sure I attended some of these meetings, but I'm too old and too forgetful to even come close to offering testimony about it. But it has evolved over time. Early back in the day, as they say, late 80s, early 90s, we would get a lead paint test. And it did seem that everybody thought, ergo, it's proof of lead. It has evolved, though, as the litigation has, as really the inspection issues have as well over time. And we've come to learn that, contrary to plaintiff's assertion, a lead paint test is not necessarily objective, indisputable evidence of lead, as they say in their brief. We've come to learn far from the case. And that's because we started to get environmental experts involved, and we saw just in the process of testing, there's a lot of interpretation. There's a lot of nuances that, if they're not done correctly, it challenges the validity of the testing. For instance, Calibration is an issue. Where the testing is done on a particular wall or structure is an issue. We've had people go out to test where the tester's ready to test the wrong property. We had a case where they changed the battery of an XRF gun in the middle of the test, just replaced it and continued, and our expert said, you can't do it that way. You have to start from the beginning. There are HUD guidelines, EPA guidelines, Maryland Department of Environment guidelines, and manufacturer guidelines on the guns that they use, the XRF guns, as to how it's to be done. We came to learn there's a lot of play in there, Your Honors. So, as a result, it raises issues as to the validity of the test.
But that goes to cross-examination. That doesn't go necessarily to being present at the testing.
Well,
because of my experiences in terms of reading the cases. When I was reading the cases, they went on destructiveness, the level of destructiveness of the testing and all of that, and protecting the property in terms of notice and whatever. All of those, I mean, we have all sorts of tests introduced in our courts where the defendant is not present at the time of the testing, you know, speeding. I mean, you know, there's the defendant's way off and comes up. We don't, and they're not present during the calibration, but they have the opportunity to cross-examine. Why is defense presence different in lead paint cases than in any other situation?
Your Honor, I would respectfully suggest it's not really different in any other situation, because this is not just a test that can be replicated. I would respectfully suggest a lead paint test is so critical, and the details of the testing are such that it's akin to destructive testing.
Because it doesn't destroy, you and I can both agree, you have experts who go to the same property.
Well, we can have experts go to the same property, but the testing result when it comes out, Your Honor, has an indicia of truth that if you're not there, you can't challenge. It is akin to destructive testing because it can't be replicated identically, because we don't even know what they did. Oftentimes, they can't tell us where they tested.
But that's the point. That's why it's cross-examination. Your being present isn't different than any other testing that's done, because we don't bring things into the courtroom.
Well, Your Honor, I would step back to other litigation.
Right.
You know, fire litigation. When the fire scene is going to be inspected, everybody's typically given notice. Everybody around. In a products case involving a defective vehicle or a defective piece of machinery, when there's testing, everybody's given notice, and when there's destructive testing, everybody's given extensive notice.
Right.
There's protocols, et cetera. And that's what we're contending, is that this testing is significant enough. And it's critical that we be there to validate the test itself.
Well,
because we can't go out and replicate what ARC did on this particular day.
So would it be the holding per se in lead paint cases that the defendant has to be present? I mean, in lead paint cases, per se, no matter what, both sides have to be present. Both sides, because it's not different for you than it is for them.
No, absolutely.
So no matter what, from now on, as a result of this case, notice would have to be given to both sides for them to be present as a result of this case.
I think, Your Honor, in all candor, that's the most fair, equitable, appropriate result for the testing. Otherwise, we go down the path that His Honor Judge Harrell was asking about earlier. You're slicing and dicing among defendants in the same case. Under the plaintiff's reading of the scheduling order, a defendant who happens to be on title at that time not only gets notice of the test, but gets to use consultants and experts, because that's wording is used in the second sentence of the provision. It says the defendant shall be permitted to attend the lead test accompanied by a consultant or experts. So one defendant would, A, get notice and be entitled to have a consultant and expert, and the others wouldn't.
But I'm saying for everybody, the plaintiff too.
I think you're right, Your Honor. I think that would be the most ideal, equitable reading of this provision.
Yeah, but I'm not concerned about, honestly, the provision, because I'm not clear that the scheduling order is what we're being called upon to interpret. I are looking at whether, in this situation, testing with notice was required. Because the scheduling order could have gotten it wrong, right?
Yes.
I mean,
Yes.
ultimately, it's not, I mean, the scheduling, we're not a court that just sort of goes, okay, they put it in the scheduling order and it's okay, if the law is not that notice had to be given. So the question then is, how is lead paint different from tire litigation? I mean, you know, I'm aware of the fact that in Baltimore City, they don't have to have notice given for testing tires,
Well,
in litigation.
and I think Your Honor is referring to the amicus
Liam,
brief, the opinion
yeah.
from Judge Carrion.
Right.
And coincidentally, similar to what I'm saying, Your Honor, with respect to destructive testing, first of all, tires and rims, there was no indication that that's not transferable testing that can be done. Judge Carrion, even in the order in that case, said, defendants shall not permanently alter the condition of the tire and rims, nor shall destructive testing of any nature be performed
Right.
without prior notice to all parties.
Right, and the question is only, from my viewpoint, as to whether this is destructive testing.
And we would argue that it is akin to destructive testing, Your Honor, because
But
it cannot be replicated.
Okay, is it destructive testing, per se?
In the sense that information is being gathered that can't be replicated. We cannot go out and the ARC group does, when they do testing in this litigation, do what's called a 40-shot lawyer survey, believe it or not. And they acknowledge that it's not in compliance with, or not in accordance with, the different lead paint assessments that are required under different national scales. So they go out and they literally test 40 areas. And if you say to them, what about it? Where on that wall did you test? It's not unusual. I'm not sure. They can't recount where they tested on that particular wall. Where did you test on that windowsill? They can't recount that. They tell you the calibration, but you don't have confirmation of that. So for the defense to try to go out and replicate that, it's virtually impossible. So it's not a matter of just having a tire pass from one to the other and your expert puts it under a microscope. This is...
But there's different places in the tire that they test.
Correct.
See, I don't know whether under your definition of destruction and reliability, I don't know whether they go together. It's not like a DNA sample where if you use it, it's gone.
Right.
And that's why you have to have notice
Right.
and
It's
everybody.
not destructive. It's
That's
not
what
destructive in that
I'm
sense.
talking.
And
Okay.
I agree with you, Honor. It's not destructive in that sense.
Okay.
But it is de facto destructive is what I'm arguing, because you can't go out and replicate it. We can't go out and replicate the test that was done to say, you know, we tracked these areas and we didn't get these results. It's virtually impossible. Just on Your Honor's question regarding notice, we mentioned in our brief, you know, when a party is not involved, when plaintiffs do testing before litigation, they must comply with 2404, you know, which is, and file a complaint to perpetuate evidence. And in that provision, all parties against whom that evidence is going to be offered receive notice. And we would argue that should have been done in this case with respect to an unowned property.
Mr. Daly,
Yes, Your Honor.
am I misreading the trial court's ruling in connection with the exclusion of the ARC report? It strikes me that, and I'm looking at the language, the ARC reports are going to be excluded as to both properties. Too late to do anybody any good, no good faith, compliance with the scheduling order. And then she refers the judge to no notice to the defendants to attend, participate, et cetera. She excluded the ARC reports, as I read this, and tell me if I have it wrong, because it was a violation of the scheduling order.
I think, back to where Your Honor, I think it's not just a violation of the scheduling order. Well, if you talk about notice, that's part of the scheduling order as well.
Right, and then she does say, I agree with you, as too late to do anybody any
Your Honor,
good.
I think another component of this is that arguably in designating experts, you're supposed to provide the expert's testimony. And this was not, they designated ARC, but they didn't give this until, again, after our deadline for experts. So I think that was all part of the equation.
Okay, all right, well.
I had one question
Yes, sir.
on the scheduling order. I'm just reading it and looking at the discovery rules. It looked like the scheduling, this provision of the scheduling order is an implementation of Rule 2422A2, which has to do with entry on land for testing, and you serve a request on a party in order to get that. That appears to be what this...
I think that's correct, Your Honor.
Okay.
I mean, there are basic discovery provisions.
Which
right.
is parties.
Yes. Yes, and I think that's some notice would be required to all parties under those basic discovery provisions.
But in terms of presence,
Well, if a party can elect, what they want to do in terms of attending a discovery device. I'm sorry, I may have missed the court's question.
Okay.
I'm sorry. And if I just may wrap up, Consumer Protection Act,
You're
it is...
taking your compatriots' time, but it's up
Yeah, just one moment.
to your side of the case.
Just with respect to the Consumer Protection Act, I would just reference that counsel, the way they frame the question, the answer is therein that if there's a violation of the Baltimore City Housing Code, we would recognize that there are other ways to prove a violation besides chipping and flaking paint, but it must proximately cause an injury. There was no evidence in this case that flat, improperly painted paint properly caused an injury at the inception of the tenancy, and that's critical to the under Benneker stature of that proof. Thank you very much.
Thank you, Mr. Daly. Mr. Parler?
May it please the Court, I'd like to echo prior sentiments. I've been asked to address the issues related to Dr. Klein, but I think in addressing the ARC issues that have been raised by the Court, it might be helpful for the Court to consider what it was that Judge White actually granted at the hearing. The motion to strike the ARC report was filed by Mr. Runkles, Defendant Runkles. It is in the record at extract page 135. Defendants vis-a-vis lines to the Court then joined those motions at record extract pages 147 and 157. And I think it's important to note that in the original motion considered by the judge, there were actually two components of Section 2C that were mentioned. Number one, the failure to provide notice to the defendants of the testing. And secondly, as stated in the motion, there's actually a timing component of 2C. It says the written request shall be made 4 months before the close of discovery. So the ARC test that was produced on August 24, 2009, under this scheduling order should in fact have been produced at least some 4 months earlier. The testing should have been completed under 2C in that time frame.
Mr. Parler, it strikes me that the respondents' collectively position with regard to its construction of the scheduling order is that it refers simply to any defendant in the case, and not, you take issue, I assume, with the petitioner's construction of it, which is the still owner defendant. So tell me why your position is the better of the two.
I think my position is, our position is the more logical of the two. Because if you look at the final sentence of Section 2C, it talks about the defendant being permitted to attend the testing with consultants or experts. And I would respectfully submit that according that litigation advantage only to a defendant owner who fortuitously through the years has managed to retain title to the property is illogical. And it's extremely important to all defendants, as Judge Harrell pointed out, because the evidence being generated is applicable to all defendants across the board, whether they attend or not. And there are significant issues. The testing we're talking about is a radioactive source. And depending on the test procedures, the test protocols, the experience and certification and licensing of the operator, there is tremendous potential at the scene, because the data is not stored in the machines by the test services as it could be. It's transferred by hand to generate flawed evidence and flawed readings. For example, if the XRF is not placed for a certain length of time so that the radioactive source can do what it's supposed to do, and it's removed, my understanding is you can actually produce a false positive reading.
All that makes sense from the perspective of any defendant who'd want to be present. I'm wondering, though, if this scheduling order really will, this 2C, is it? The one we're talking about.
It actually has
The
been,
it's
since been changed to 2E, but for this case it's 2C.
Okay, then 2C. Wouldn't a reasonable interpretation of that scheduling order be simply to facilitate and to require an owner of the property to make the property accessible to the plaintiff for purposes of testing? Really, the logistics of, I'm speculating here. It seems to be essentially the position of the petitioner. Tell me why that is an incorrect
I think
construction of the wording of the scheduling order itself.
I think certainly the first sentence addresses a problem, and it was a problem of people needing to set up the testing, not having access, and needing to take care of that through the present owners. But then the rest of that section, where it talks about consultants and experts, we do not agree that it was the intention that only the owner that has retained title through the years should enjoy that tremendous litigation advantage. And the advantage is, if you're there with your own consultants and experts, and they can give you a list of everything that was done wrong, all the potential malfunctions of the ARC machine, all the calibration checks that they didn't perform, you come away from attending that testing with a list of cross-examination questions and potentially the basis for a motion to exclude if the violation of the test protocol was significant enough to support a motion to exclude the testing, violation of the HUD regulations, violations of the performance characteristic sheets prepared by the manufacturers as to how the tests are to be conducted and performed. So I think Your Honor is right. It addresses an issue of access. But I also think the intent here, and certainly the language, indicates that all sides should be permitted to observe, assess the data collection, assess the procedures, because if you lose that right, you've lost potentially an entire page of cross-examination questions for that tester, and potentially even the basis for a motion to exclude.
Do defendants in these cases do testing on the properties?
They do from time to time, particularly if they do.
And so do plaintiffs have a right under the scheduling order to attend those?
I think if the plaintiff's attorneys made a request and we would be more than happy to have them in attendance, because the goal here is to get it right.
But is there a right under the scheduling order to do that?
For this case, under 2C and for 2E, I don't think there's any mutuality at this point, but certainly I don't know anyone on the defense side that would oppose having anybody that wanted to be present for the testing.
Assuming that they had notice of it, I suppose.
Assuming everybody had notice and there was an opportunity to retain and bring in the consultants and experts.
Well, they would have to be given notice.
Absolutely.
I mean, that would be a requirement
Absolutely.
under the holding, isn't that correct?
Absolutely. I
I
think,
mean, that if we were to hold that, as your co-counsel said, Mr. Daly, it would have to be, both sides would be required.
I concur.
But it's not required under the scheduling order.
it's not presently a requirement under Section 2C of the scheduling order, but I think it would be tremendously important for all parties to have access to the testing so that we get the testing right. Because there are problems, there are issues, there is flawed evidence being generated, and I think it's very important for both sides to have access to that testing during the course of the case.
I'm a little concerned still with the notion that the interpretation of 2C historically either has been as Mr. Brown presents, as Mr. Kerpelman in his affidavit, as Mr. Nevin in his affidavit, for some period of time in Baltimore City on both sides of the courtroom. Disabuse me of that. I mean, is the defense bar taking an entirely contrarian point of view on how 2C is to be read up until this case?
There certainly has, and I've been involved in this litigation, as is Mr. Daly, as is Mr. Brown, Mr. Kerpelman for many years. There's certainly been occasions where there's been joint testing and notice prior to this case.
What I'm talking about is an entitlement pointing to 2C or something else. In other words, as I understand 2C, I mean, 2C could generously be read as ambiguous. But by the same token, it's being argued to us by the petitioners here. It's not ambiguous. It's always been understood that the only person on the defense side of a case who's entitled to notice and opportunity to attend the plaintiff's testing of the subject property is the still owning defendant.
I can speak for myself. That has not been my understanding.
Do you stand in a minority in the defense bar in that regard?
I don't. I can't speak for the defense bar, Your Honor. I do think that in looking at 2C, that there is a right, and given what we know about this litigation at this stage, there should be a right for any defendant potentially affected by this testing to attend it with consultants and experts so that they're not at trial at a distinct disadvantage to those owners who have had consultants and experts in attendance, and so that all defendants potentially affected by this evidence have an opportunity to participate fully in the data collection and to prepare adequately for cross-examination and, if necessary, motions in limine.
Wrap it up, counsel.
Just briefly on...
Very briefly. Your time is exhausted, so very briefly.
Yeah. Just on the Dr. Klein issue, I think it's important to note this suit was filed in 2007. By 2009, the parties had been operating under 4 revised scheduling orders, and we received an affidavit October 26, 2009, that drastically, as Judge White pointed out, changed the landscape of this case. We had a doctor saying, even though there was no evidence of the child being outside, that because of exterior testing, there was interior lead-based paint. And we think that she did not abuse her discretion in excluding Dr. Klein.
Thank you, counsel.
Thank you, Your Honor.
So it's Mr. Kerpelman. All right. And you have, how much time, Mr. Kerpelman? Excuse me, Judge. 5 minutes. All right.
Mr.
Judge Harrell.
Would you pick up right where Mr. Parra left off? And that is, when did the defense cry foul, if it did, about Dr. Klein?
I don't think they ever did, Your Honor.
That was solely Judge White probing.
Judge White conducting what the respondents have in their own brief called an investigation, and what motion she actually was granting. I don't think we still have any specific idea, because Again, Your Honor, I was very pleased to hear Judge Battaglia question the so-called issue of the extension of Rodriguez versus Clark, because I can tell the court that, in fact, that is what is happening down below, and that is what happened in this case, because the court below, Judge White, and in fact, we had a prior instance of it where we sought cert, but unfortunately it wasn't granted. Judge White treats, and other judges now that the Court of Special Appeals opinion in this case exists, judges below and it's something this court has to consider, are treating Rodriguez as having created a new category of, quote, discovery failures which are subject to immediate sanctions. Because the way that it is taken below is that the court has the power to sanction violation of not obeying the scheduling order. And so if the judge can sua sponte look through the pleadings, which is quite apparent is what happened in this case, in camera, ex parte, and identify what the court decides are failures to obey the scheduling order, then the plaintiff can be subject to immediate sanctions, which is, in essence, what happened in this case.
At the core, the Dr. Klein issue, that argument,
Yes.
At core, your argument is that it was unfair ambush.
Exactly, Your Honor. I think
Because if Judge White had said, you know, I think there's a problem with this designation of Dr. Klein. I know it hasn't been brought up by the defense. You're probably not prepared to deal with it today, so we'll carry that over for a week and then come back and talk to us about it. You wouldn't be able to argue unfairness at that point.
Well, I think we'd be in a different posture, Your Honor. I probably would still be arguing that you can't assess immediate sanctions for not following a scheduling order, because I would say that since the scheduling orders are about timing, not about substance, that if the issue is the adequacy of a response rather than the timeliness of the response, then you're thrown back to the provisions of Rule 2-432 and 433, under which only two categories, which we all know exceedingly well, allow immediate sanctions. And anything else has to have an order to compel discovery preceding it. And I would also point out to the Court, this is where what you've said is totally apt, Judge Harrell. Both of those rules require a motion, because the rules 432 and 433 say upon motion, upon notice to the other side. And obviously if there's a motion and there's notice and you're going to be able to file a response, then you're also going to get a hearing on it. So, yeah, ambush, blindsided, and I would argue to the Court that if this expansion, however you want to characterize it, of Rodriguez is allowed to continue, it's going to ruin what exists already in the lead paint bar, at least, where we are very cordial bar. We freely exchange the information. There isn't holding back. There isn't trying to surprise somebody with the expert's opinion. Sometimes there's scheduling problems, but as in this case, the scheduling problems are worked out. Dr. Klein's deposition was scheduled at the time that Judge White took the action that she did, but without notice. That
was a joint scheduling, was it not? Both sides agreed to the timing?
Both sides agreed. And then to the ambush issue, Your Honor, I realize that appellate advocacy requires you to try to hold on to what you have, but I think that Mr. Daly is stretching it a little bit by raising the timeliness issue, because no one ever said, I mean, there's no defense motions that say motion to compel, motion for sanctions. We didn't know about Dr. Klein. In fact, they're sitting there at the motions hearing getting ready for the deposition that they've already scheduled and already agreed to, so that they can find out the exact detailed specifics of what he was going to say. And I think really what happens is, I guess, the prospect that we face is the requirement to have no second chances, because there's going to be immediate sanctions for anything that the judge deems to have been an inadequacy under the scheduling order. So you're not going to have the provisions of 432 and 433, which say have a motion, have a hearing, work it out, and then the judge gives you the guidance of an order compelling discovery, and then you're put to the test whether you're going to obey that order or not. Instead, it would create this system where you have to guess ahead of time what the judge is going to say you were required, what kind of details you were required to give in your expert designation. And then if you guess wrong, you're out of luck because it's immediate sanctions for disobeying the scheduling order. And that's a system that can't work, isn't fair. There's no rule that supports it. I would say it's unconstitutional. You're entitled to due process. You're entitled to know what the failing is with your expert designation.
Well, with that, the case is submitted. Thank you, counsel.
Thank you.
The court will take a brief recess.
All right.
And we will have counsel in number 2, Lippitz versus Hurwitz, be present at counsel table when the court returns.